We're in session in County Court, Law number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. We'll be calling our announcement docket, which was scheduled at 9 a.m. on this morning on today's date of September 22nd of 2021. First case we're calling is cause number 330294. Case is style of State of Texas versus Cassandra Dawn Blaylock. We have Ms. Blaylock appearing via Zoom. Ms. Blaylock, you can take your mic off of mute. Ms. Blaylock, how are you doing?
I'm good. How are you, sir?
I'm doing fine. Thanks for asking. Ms. Blaylock, you're represented here by your attorney, Mr. James Macon, who is also appearing via Zoom. Mr. Macon, how are you doing?
I'm doing wonderful, Your Honor. Thank you for asking.
Mr. Macon, do you have an announcement you'd like to make in Ms. Blaylock's case?
I do, Your Honor. On August 12th, we requested the DVDs and videos, and we don't have those yet. So I'm going to ask just for a short reset so I can get and review those with my client.
Okay, could you give us a date? Okay, your case is reset to November 17th of 2021. Mr. Macon and Ms. Blaylock, stay in contact with your attorney and your bondsman. Your case is reset to November 17th of 2021. This will conclude your case. You're free to go, and you have a blessed day.
You too. Thank you, sir.
You're
Thank
welcome.
you, Judge.
Okay, and you're free to go as well, Mr. Macon, and you have a blessed day.
You too.
We're in session in cause number 326148. Case is style of State of Texas versus Crystal Shavetta Foxall. We have Ms. Foxall appearing. I thought she was on Zoom. Okay, would you, Mr. Bailey, would you please go get Ms. Foxall? Ms. Foxall, you come forward. Okay, this is cause number 326148. Case is style of State of Texas versus Crystal Shavetta Foxall. Ms. Foxall, how are you doing? I'm doing fine. Thanks for asking. Ms. Foxall, you're represented by your attorney Ryan Gertz. He's appearing via Zoom. Mr. Gertz, how are you doing?
Great, Judge. Good morning.
Good morning. Mr. Gertz, you have an announcement you'd like to make in Ms. Foxall's case?
I do, Judge. We just got a new offer from Ms. Maxey, I believe either Monday or Tuesday of this week, and I need maybe 30 additional days to discuss that with Ms. Foxall, and I think we may be able to resolve this case without a trial.
Okay. Okay, this case will be reset to November 17th of 2021. Ms. Foxall, you can get your reset from our court coordinator in court. Once you get your reset, you'll be free to go. Stay in contact with your attorney and your bondsman, and you have a blessed day. Stay on for us. And Mr. Gertz, I think this is your only case. Is that correct?
It was, Judge. Thank you very much. Have a great day.
All right, you'll be free to go, and you have a blessed day as well. Thank you. Who's Meg, not ready? The prosecutor? You can move the prosecutor on.
You the prosecutor on Mr. Shenanigans case? I am. Can I ask you a question real quick? Okay, so I'm showing this for this one, so are we dismissing the other one? What's the name of it?
Okay. Mr. Hall, are you ready?
I just put a zero instead of it. Yeah, the UCW. Okay, that's okay. Thank you.
Mr. Hall, are you ready? You, we could, you have Blake Sedita?
Yes,
I'm
Would you-
preparing the paperwork. Your Honor.
Oh, okay, we'll hold on it. We'll come back.
and we also have Mr. Fonda, he's outside.
Okay. Okay, once you go get Mr. No, that's LeBlanc, Reginald LeBlanc.
Oh, I'm sorry.
Mr. LeBlanc, take off your hat. Yeah. Okay, this is cause number 329-818. The case is styled the state of Texas versus Reginald C. LeBlanc. Mr. LeBlanc, how are you doing?
Good, how you doing, sir?
I'm doing fine. Mr. LeBlanc, you're here represented by your attorney, Mr. Willard Hall. Mr. Hall, how are you doing?
Doing great, Your Honor, thank you.
Mr. Hall, you have an announcement you'd like to make in Mr. LeBlanc's case?
Yes, sir, we would request one more resetting in 60 days. We're still waiting to have his driver's license suspension hearing, and after that, we should be in a better position.
Okay, could you give us a reset?
17,
What is it?
11/17.
Okay, the case is reset to November 17 of 2021. Mr. Hall, you can get your reset. And Mr. LeBlanc, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Thank you, sir.
Get the paperwork on that now.
I'm not. Okay, he's like,
Okay. We're in session in two cases. First case is cause number 328-810. Second case is cause number 328-812. Both cases are styled the state of Texas versus Winston Brian McKnight. Yes, prosecutor. Mr. McKnight, your full name is Weston Brian McKnight?
Yes, sir.
Okay, Mr. McKnight, would you please raise your right hand? Mr. McKnight, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. McKnight?
Good, you?
I'm doing fine. Thanks for asking. Mr. McKnight, you're here represented by your attorney, Mr. Mel Shalander. Mr. Shalander, how are you doing?
I'm okay, Judge, thanks.
That's good. Mr. Shalander, do you waive a record in Mr. McKnight cases?
We do.
Okay. Mr. McKnight, I have before me an information in cause number 328-812. And this information alleges that on or about November 3rd of 2020, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. McKnight, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. McKnight, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. McKnight? Okay, let me do this here. You had B right here. I gotta change it to the box that says DWI first.
Oh, I'm sorry.
Okay. Now, Mr. McKnight, let me show you State's Exhibit number 1, misdemeanor plea admonishment. I checked that box off. Do you recognize this document?
Yes, sir.
Now, the box that I check off, I'll just read it to you. It says driving while intoxicated, DWI, first offense, Class B misdemeanor, confinement in jail for at least 72 hours, but not to exceed 180 days, a fine not to exceed $2,000, or both such confinement and a conviction resulting in community supervision will require the drug, alcohol evaluation, rehabilitation, payment of costs of rehabilitation, completion of an alcohol education program. And the last part, it says, in ignition interlock, if you had a breath alcohol concentration level of 0.15 or more. Do you understand that?
Yes, sir.
Okay, now on page 2 of this same document, there are a set of initials on a line next to a box that's titled Nola Contendere, which means no contest. Did you place your initials on this document? On page 3 of this same document, Mr. McKnight, there's a signature at the top of this document above the line that's titled Defendant. Did you sign this document?
Yes, sir.
Okay. And on the next document, which is titled the Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled
Yes, sir.
Defendant? There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I also have before me a document that is titled the Discovery Certification. Mr. McKnight, do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled Defendant?
Yes, sir.
Now, Mr. McKnight, prior to signing and initialing these documents that I have just mentioned, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1, which is the misdemeanor plea admonishment. State, would you like to offer State's Exhibit number 2?
Yes, Your Honor.
That's probable cause affidavit. Now, no objection. State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavit, will be admitted. Mr. Sherlander, you have advised and counseled Mr. McKnight. Is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge, Judge.
Mr. McKnight, your attorney, Mr. Sherlander, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. McKnight, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The agreement is for 180 days probated over 1 year, a $1,000 fine, 80 hours community service, DWI education, drug and alcohol assessment, and forfeiture of the weapon, which the state has the motion of forfeit for you, Judge. And lastly, the dismissal of cause number 328810. And I filed the dismissal.
And that's the forfeiture of the weapon in cause number 328810. Is that correct?
Your Honor.
And that cause number will also be dismissed. Is that correct?
Correct.
Yeah.
Okay, well, I'm gonna change the number.
Okay.
Yeah, 18 down here. Figures
Oh, I'm
isn't
sorry.
18. Okay.
Here's what's mixed up.
Okay. What we're gonna do is, on the judgment, we're gonna say forfeit weapon and cause number 328810. Okay, I'll read it to her first. Okay, now, Mr. McKnight, the state is offering that you serve 180 days in the Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you will be on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $422, which comes to a total of $1,422 of fine and court costs. You'll be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay a Jefferson County DWI education class and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. The total amount that you'll be required to pay each month in monthly installments is $205. Mr. McKnight, will you be able to pay the $205 each month?
Yes, sir.
You will also be required to perform 80 hours of community service, attend and complete a DWI education class, and have a drug and alcohol assessment. And cause number 328810 will be dismissed. And the weapon in cause number 328810 will be forfeited. You will also be required to adhere to the other standard terms and conditions of probation. Mr. McKnight, do you understand the state's offer?
Yes, sir. Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, now, and as part of that, I have this motion to forfeit the weapon in cause number 328810. Mr. McKnight, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled Defendant?
Yes, sir.
Prior to signing this document, did your attorney go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. McKnight, I'll be granting the motion to forfeit your weapon in cause number 328810. Is it 22nd? Now, Mr. McKnight, again, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. McKnight, I'll follow the plea bargain that you have entered into with the state. Mr. McKnight, you're gonna stand on the X next to your attorney, and you're gonna follow the directions of our clerk. And once you finish following her directions, you'll be free to go and you have a blessed day.
You too, Your Honor.
Thank you. This is the one that, this is the.
Right, thumbprint. Lift it up and then say, start again. Start again. Thank you. There's a signature pad right here. If you would sign for me, you won't see it, but I will.
Who, Mr. Baylor, could you please get Maria Ibarra? Oh, okay. This is cause number 325514-2. Case is style of State of Texas versus Maria Mercedes Ibarra. Your full name is Maria Mercedes Ibarra. How you doing, Mr. Barra? I'm doing fine. Thanks for asking, Mr. Barra. You're here represented by your attorney, Mr. Ted Jones Jr. Mr. Jones, how you doing?
Pretty good, sir.
That's good. Mr. Jones, do you have an announcement you'd like to make in Mr. Barra's case?
She's been approved for pretrial diversion,
Okay,
and I think the court date contract is October 12th. October 12th, we're supposed to sign the contract.
okay, so we're gonna reset this to the second, October 12th. That's kind of, it's usually the first Thursday in October.
I don't remember the date.
What is it? What's the first Thursday in October?
I thought it was October 12th.
It's not on the 7th? Normally they have it on the first Thursday of the month, unless they reset it. We'll just give her 3 weeks after October. 3 weeks, the third week in October. That'll be after the signing date.
October 25th.
Okay. Case is gonna be reset to October 25th of 2021. And basically what we're doing is we reset it at that time because once you go into, you sign up, they're gonna dismiss the case the next day. And so by the time this day come up, the case will already be dismissed.
So we still need to make an appearance on that.
No, if it's dismissed, you don't have to make an
Okay.
appearance.
Yes, sir.
You gotta make an appearance to sign up.
Yes, sir.
Yeah. Now, that's what we anticipate. Now, if she doesn't show up to sign up, then the case is still there. But you can just kind of check with us if you know, if you want to be safe, to say, well, let me check, make sure. Okay.
Yes,
But normally that's what happens.
yes.
Okay. So his case is going to be reset to October 25th of 2021, and we show that you signing up for pretrial diversion. So, Mr. Jones, you can get your reset
Yes.
from our coordinator. Once you get your reset, you'll be free to go. And Ms. Barrow, once you get your reset from your attorney, you'll be free to go as well. Ms. Barrow, you have a blessed day. Mr. Jones, you have a blessed day as well.
Thank you, Your Honor.
You can sign for me. No, Mr. Jones. Sign for your reset.
That guy walked in.
Yes, thank you.
Are you up? Mr. Okay. It's up here. Would you please call Flowers? Let me see there was an assessment or a psychiatric exam in the file.
Or which one?
Flowers, 327762. That's back what I.
Oh, they put it on there. I'm sorry.
Did you find it? Yes. Y'all ready on Mr. Flowers? Okay, this is cause number 327762. Case is style State of Texas versus Carl Wayne Flowers. Mr. Goodluck, y'all need some more time on it?
Well, Judge, this is a case, the last time we were here, we attempted to plea it, and the court had concerns about competency. Dr. Verpog is found incompetent, but,
All right, I remember.
yeah, but, if the court's ready to accept the plea, we can draw it up and have it done.
Well, just draw it up.
Okay.
Yeah, okay, and we'll see. Okay, you could have a seat, Mr. Flowers. Okay, who else? Are we ready on, yeah, they still working on Sedata?
I'm finishing up now.
Okay. I suppose I didn't sign that, no, I need to do that dismissal on,
Oh.
McKnight.
I just wrote it on there. and I
Okay.
dated it, but I just wanted to-
Okay.
You did what?
I had forgotten to write forfeiture of the weapon on city as one of the conditions, but I wrote it.
Oh, you talking about on the plea form?
Yes, sir.
Yes. Because we wrote it on the judgment.
Oh, no, I,
Oh, yeah, it's over there. No,
No.
yeah, that's,
Judge, may I approach?
Yes. Hold on. Okay, says, let's see. Oh, okay, Alfredo Reyes, please call Alfredo Reyes.
Good morning, sir.
Good morning. Do we have bond conditions in Reyes case? 327696. Yeah. We did? Okay. We're in session in cause number 327696, case is style of state of Texas versus Alfredo Reyes. We have Mr. Reyes appearing in person. Mr. Reyes, how are you doing?
Good, sir. How are you doing?
I'm doing fine, thanks for asking. Mr. Reyes, you're here represented by your attorney, Mr. Don Boudreaux. Mr. Boudreaux, how are you doing?
Just fine.
That's good. Mr. Boudreaux, do you have an announcement you'd like to make in Mr. Reyes' case?
Yes, sir. We have to put this on a file.
Okay, we're gonna reset it for a trial. Could you give us a trial date?
January the 10th.
Okay, this case is going to be reset to January 10 of 2021. Excuse me, yeah, that's it. January 10 of 2022. And Mr. Reyes, once you get your reset from your attorney, you'll be free to go. And you have a blessed day. And Mr. Boudreaux, you can get your reset. And this is your only case, so you'll be free to go as well. You have a blessed day.
Thank you, sir.
Okay, we ready on, data? We're in session in cause number 329628 and cause number 329632. Both cases are style of state of Texas versus Blake Emmanuel Sedita. Your full name is Blake Emmanuel Sedita.
Yes, sir.
How you doing, Mr. Sedita?
Good yourself?
I'm doing fine. Mr. Sedita, I have before me an information that alleges, in cause number 329632, the information alleges that on or about March 6th of 2021, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class B misdemeanor offense of driving while intoxicated. Mr. Sedita, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Sedita, how did you plead? Guilty, not guilty, and no contest?
Guilty.
Now, you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, now, Mr. Sedita, I have before me a misdemeanor plea admonishment. The box there, that one is checked. Mr. Hall, I'm gonna change that from that B to here to where it says DWI first. That's the box. Okay. Now, Mr. Sedita, I've just checked off a box here that reads driving while intoxicated, DWI first offense, Class B misdemeanor, confinement in jail for at least 72 hours, but not to exceed 180 days, a fine not to exceed $2,000, or both such fine and confinement. A conviction resulting in community supervision will require a drug/alcohol evaluation/rehabilitation, payment of costs of rehabilitation, completion of an alcohol education program, and if your blood test was if they would have followed as a DWI, first with an alcohol concentration level of 0.15 or more, then you would have been required to get an interlock, but yours is not filed as that. Now, do you understand what I just read?
Yes.
Okay. Now, on page 2 of the same document, these are your initials. Yes, that's the same. Okay. On page 2 of the same document, are these your initials on a line that's titled guilty?
Yes, sir.
On page 3 of the same document, is this your signature above the line that's titled
Yes, sir.
defendant? And on the next document, which is the trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I also have before me a document that is titled the discovery certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Okay, Mr. Sedita, prior to signing and initialing these documents that I have just mentioned, did your attorney, Mr. Hall, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
Mr. Hall, you have any objections?
No objection.
No objection. State's Exhibit number 1 will be admitted. Mr. Hall, you've advised that counsel, Mr. Sedita, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Sedita, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Sedita, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that you plead guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 1 year deferred probation.
I'll take you.
Sorry, a $500 fine, 60 hours community service, DWI education, drug and alcohol assessment, an interlock device, forfeiture of the weapon, and cause number 329628. And I provided the motion to forfeit, plea judge, and also dismissal of cause number 329628.
That's DWI education. In a lot. Three, 2, 9, 6, 2, 8. And we'll dismiss that. So 6, 2, 8. Your software is date. Let me do this. What was the, did he have a breath test in this case? Did he have a alcohol concentration,
Are you
BAC?
talking about why the interlock is on there?
No. I'm saying, if he's often deferred, I think the,
It was
Well-
1.15.
Huh?
It was 0.108. It was below 0.15.
it was 0.108, that's what you're saying?
108.
Okay, so it was less than 0.15.
Yes, sir.
Because I think the statute states that if he had 0.15 or more, he does not qualify for a
Deferred.
deferred, but his is
Correct.
lower than that.
Right.
That's why I was asking the question.
Oh, okay.
Okay, and does his license, is it a regular driver's license or is it a CDL?
His regular.
So you did not have a commercial driver's license, right?
No, sir.
Okay, because if he had a commercial, he'd be ineligible. Okay, okay, they're saying it's after September 1st of 2019. Okay, if it's before, he will not be eligible, okay? Let's see. Now, Mr. Sedita, the state is offering that you serve 1 year deferred adjudicated probation. During this 1 year probationary period, you'll be required to pay a fine of $500 and court costs of $407. Your total fine and court costs is $907. You'll be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to pay a Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, the total amount of your monthly installments, that is how much you will have to pay per month while you're on probation, is $160. Will you be able to pay the $160 each month?
Yes, sir.
Okay. You'll also be required to perform 60 hours of community service.
40 hours.
Oh, it's 40?
No, our deal is 60 hours, Mr. Hall.
27, 46, 48.
Oh, so the email I sent you yesterday had.
Oh, okay. Hold on. We'll just be in recess. Now, in reference to cause number 329628, Mr. Sedita, did you, the state has filed a motion to forfeit the weapon. And in this document, Mr. Sedita, there's a signature on the line that's titled Defendant. Do you recognize this document?
Yes, sir.
And is that your signature on the line that's titled Defendant?
Yes, sir.
Prior to signing and initially in this document, did your attorney, Mr. Hall, go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Sedita, I'm signing the motion to forfeit the weapon in clause number 329628. And that motion will be granted. And just for the record, Mr. Sedita, you acknowledge that in this judgment, the state was offering you $500 fine plus court costs, $407, which came to a total of $907. They also, you were required to pay a $60 probation fee each month, your analysis fee of $15 each month, and you will also be required to pay the Jefferson County DWI education and initial evaluation fee of $125, and the total amount of your, should a further evaluation be needed, you will be required to pay an additional $50. And you were, the total monthly installments was $160. You acknowledge that you'll be able to pay the $160. The state also offered that you perform 40 hours of community service. You will be required to attend a DWI class and have a drug and alcohol assessment. You will install a DWI interlock device on any vehicle that you own or operate. And the following case, cause number 329628 will be dismissed. And as part of this plea bargain, you forfeited the weapon in cause number 329628. And you acknowledge to the court that you understood the state's offer, that the state's offer was fair and just, and that you accepted the state's offer. Is that correct?
Yes, sir.
And the court is following the plea bargain agreement that you have entered into in both cases, in cause number 329628 and cause number 329632. Now, Mr. Sedita. Oh, that's okay. Now, Mr. Sedita, because you are getting deferred probation in cause number 329632 and pursuant to Article 42A.101B, I must inform you orally or in writing of the possible consequences under Articles 42A, 108.108 and 42A.110 of a violation of a condition of deferred adjudication supervision. And okay, and Mr. Sedita, pursuant to Article 42A.108, on violation of a condition of deferred adjudication, community supervision imposed under Article 42A.104, the defendant may be arrested, that you may be arrested and detained as provided in Article 42A.175. Now, if that happens, you'll be entitled to a hearing limited to the determination by the court of whether the court will proceed with an adjudication of guilt on the original charge, and the court may not proceed with an adjudication of guilt on the original charge if the court finds that the only evidence supporting the alleged violation of a condition of deferred adjudication community supervision is the uncooperated results of a polygraph exam. The determination to proceed with an adjudication of guilt on the original charge is reviewable in the same manner as a revocation hearing conducted under Article 42A.751D in a case in which the adjudication of guilt was not deferred. And you should be advised that the court retains jurisdiction to hold a hearing under subsection B and to proceed with an adjudication of guilt regardless of whether the period of deferred adjudication community supervision imposed on the defendant has expired. if before the expiration of the supervision period, the attorney representing the state files a motion to proceed with the adjudication and a capias is issued for the arrest of the defendant. And in Article 42A.110, and it reads, proceeding after adjudication. After adjudication of guilt, all proceedings including assessment of punishment, pronouncement of sentence, granting of community supervision, and the defendant's appeal continues as if the adjudication of guilt had not been deferred. A court assessing punishment after an adjudication of guilt of a defendant charged with, this doesn't apply to you because it only talks about a state jail felony. So, Mr. Sedita, if you successfully complete your probationary period, your case will be dismissed. It will not appear in your record, and you may qualify for non-disclosure. You can talk to your attorney, Mr. Hall, about a non-disclosure. He's quite competent in those matters. And Mr. Sedita, stand on the X next to your attorney and follow the directions of our court clerk. And once you finish, you'll be free to go and you have a blessed day. Mr. Hall, you'll be free to go as well and you have a blessed day.
Appreciate it. Thank you.
Is that your right one, please?
Let's see, we got Mr. Did, Mr. Bailey.
You won't see it, but I will.
Yeah, I see Mr. Pat. Did Mr. Sidney Bill show up?
I don't think so. He has
Okay.
one that's here.
Okay, let me see. Yeah, see if all the ones he have bring them in. If they,
Your Honor, if I may, Your Honor, Mr. Bill, we approached last time and actually the family sent some documents to you. I'm pretty sure he has Castleman's disease and he was last
okay.
court setting in a long-term care facility.
Okay, I
And,
remember that.
Now I have not received updated documents from him. I have a call into them right now trying to get some updated documents because I myself am concerned about where he is. He was not doing well last time we approached
Yeah, I
the
remember
court.
that. Yeah, I
He had had
remember
a
that.
stroke and he's a very young man too, so I'm a
Right.
little concerned, but I'm doing my best right now to locate documents, to locate a family member to get documents to update the court.
Okay.
And I
Okay,
didn't
thanks
mean
for
to
that.
jump in. I just wanted to make you
No,
aware.
no, thanks for that reminder.
Yes, sir. He's just been very responsible and the family's been very responsible with me
Right,
up to this point.
okay.
But I fear there's been a problem because normally I hear from a family member by now, so, and I have not.
Okay. Okay, Lucas, okay. We're in session in cause number 329-388, cause number 329-392. Case is styled the State of Texas versus Jordan Dwayne Lucas. We have Mr. Lucas appearing in court. Mr. Lucas, how are you doing? That's good. Mr. Lucas, see if we got a bond condition. Mr. Lucas, you're represented here by your attorney, Mr. James Padgett. Mr. Padgett, how are you doing?
Good morning, Your Honor. I'm doing
Good
well.
morning. Now, Mr. Padgett, you have an announcement you'd like to make in Mr. Lucas' case?
Yes, Your Honor. We would ask that the family violence case be placed on your trial docket, and obviously, since the unlawful carrying is along with it, we would ask that that be set on your trial docket as well.
Okay, do we have? Okay. Okay, now, Mr. What day? Okay. This case is reset to January 10, 2022. Mr. Lucas, you're gonna stand on the X and get your reset on the 4X and get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. Let's see.
Your Honor, I have Max McKelvey, and he is supposed to be attending by Zoom. I'm not sure whether he's up on Zoom right now. I've given him the Zoom ID, and communicated with him this morning.
Okay,
If he's not,
Mac,
I need to-
it's Max McAwee.
Yes, sir.
Okay, I don't think he's there.
Okay, then what I need to do is,
That phone number is might be, what did you say?
I said that I'll need to step away and contact him.
Okay, that's
to-
fine,
to get
that's
him up
fine.
on Zoom. So you'll
That's
just have to come back to me, Your Honor. I appreciate your time.
Yeah, that's fine. We'll hold on it.
Okay, thank you, Your Honor. I'm going to step away
Okay.
now. May I be
Okay.
excused for a few moments?
Yes, you may be excused.
Okay, thank you.
Let's see, we got, Justin, no, he's not here. Who else I think? Hernandez, this is Galmore. Who's Simmons? Okay, who is, I was seeing on the Zoom. Simmons.
Judge, if I may, I believe I heard you say Galmore. I am appearing for Mr. Galmore today.
Okay, okay, I didn't know that. Okay.
I'm not trying to jump in line, but I am
No, I
appearing for
see.
Mr. Galmore.
Okay,
today.
okay. Let's see, let's see, but those people's been on Zoom, they've been on there for a while. Okay. We're in session and cause number 327-860. Case is style of State of Texas versus David Alexander Azuquera Borjas. Mr. Azuquera Borjas, you can take your mic off of mute. Mr. David Azuquera Borjas, you can take your, okay, mic off of mute. Mr. Azuquera Borjas, how are you doing?
Doing good, sir. How about you?
I'm doing fine. And you're represented here, you actually represented by Dustin Galmore, but Dustin Galmore is not here. We have Mr. McIntosh, Charles McIntosh, who is substituted in for Mr. Galmore. Mr. Azuquera Borjas, does Mr. McIntosh have your permission to stand in for Mr. Galmore?
Yes, sir.
Okay. Mr. McIntosh, how are you doing?
I'm doing well, Judge. Thank you.
Mr. McIntosh, you have an announcement you'd like to make in Mr. Azuquera Borjas' case?
Yes, Your Honor. We would like to plea this case in about 4 weeks. So if I could just get a reset for 4 weeks, I don't care if we leave it on this docket, that's fine, but we do plan on pleading in 4 weeks.
Okay, give us a date. Just give us any time within the, we can't give it an, just give us an October date. He said 30 days to plea.
October 25th.
Okay, it's gonna be reset to October 25th. And
That's great,
Mr.
Judge.
Okay, Mr. Borjas, your case is reset to October 25th of 2021. Stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
You too. Thank you, sir.
Okay, you're welcome. Okay. Our next case is cause number 328-826. This case is styled the State of Texas versus Eloy Hernandez. Mr. Hernandez, you could take your mic off of mute. How you doing, Mr. Hernandez?
Pretty good. How about yourself?
I'm doing fine. Now, Mr. Hernandez, you are represented by Mr. Dustin Galmore. Mr. Galmore is not here. However, we have Mr. Charles McIntosh, who is standing in for Mr. Galmore. Does Mr. McIntosh have your permission to stand in for Mr. Galmore?
Yes, sir, he does.
Okay. Mr. McIntosh, what is the announcement in Mr. Galmore's case?
This one with Mr. Hernandez, and we are waiting on a pretrial diversion answer, Judge.
Okay. So I'll reset this one till, we're gonna reset this one till the second week in December.
Okay.
That's I guess the next pretrial after October. What is that?
12/13.
It'll be December 13 of 2021. Mr. Hernandez, stay in contact. Your case has been reset to December 13th of 2021. Stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
Yes, sir. You do as well.
Thank you. And the next case is cause number 329158, the state of Texas versus Russell Simmons. Mr. Simmons, you could take your mic off of mute. Mr. Simmons, how you doing?
I'm doing good today. How about you, Your Honor?
I'm doing fine. Now, Mr. Simmons, you're here, well, you're represented by your attorney, Mr. Dustin Galmore. Mr. Galmore is not present. We have Mr. Charles McIntosh who's standing in for Mr. Galmore. Does Mr. McIntosh have your permission to stand in for Mr. Galmore?
Yes, he does.
Okay. Now, Mr. Simmons, excuse me, Mr. McIntosh, what is your announcement on Mr. Simmons' case?
On Mr. Simmons, Judge, we would like to announce trial.
Trial, okay. Okay, that case is going to be reset to January 20, 2022. Mr. Simmons, stay in contact with your attorney and your bondsman. Your case is reset for trial on January 10 of 2022. This will conclude your case. You're free to go and you have a blessed day.
Thank you.
All right. And Mr. McIntosh, the reset will be sent to Mr. Galmore. And the next case we have is Michael Resendez.
Yes, Judge.
Okay, he's out in the hall. This is cause number 329306. Case of style of state of Texas versus Michael Anthony Resendez. Is that your full name?
Yes, sir.
How you doing, Mr. Resendez?
I could be doing better.
Well, you could be doing worse too. So you're doing all right? All right. Now, Mr. Resendez, you're represented here by your attorney, Mr. Charles McIntosh. He's appearing via Zoom. And Mr. McIntosh, you have an announcement you'd like to make in Mr. Resendez's case?
Yes, Judge. I have been able to get discovery in this case, but I do need one more reset on an announcement docket in order to speak with the district attorney's office and my client. So if I could just ask for one more resetting, please.
Okay, that case is going to be reset to November 17th of 2022. Now, Mr. Resendez, you can stand on the floor. Actually,
Judge, I'm sorry, Judge. Can we get like a week? Can we go in December, like the first part of December?
Okay, that's fine. Hold on a minute. Just hold on a minute. December 1st or the 8th?
8th would be great, Judge.
Okay, so we're gonna reset this case to December 8th. Mr. Resendez, you can stand on the floor.
Can I get his number?
Oh, he said he needs your number. We'll provide it to you on your reset.
Okay, Judge. Okay, thank you, Judge.
Okay, you're welcome, and I thank Mr. McIntosh. Your reset will be sent to you. This will conclude your cases that you had today. You're free to go, and you have a blessed day.
Thank you, Your Honor. You as well.
Okay, and Mr. Resendez, once you get your reset, you'll be free to go as well, and you have a blessed day. Okay. Did Aaron Lee ever show up? Yeah, for Mr. Joe Vasquez.
Good morning, Your Honor. Did I hear my name?
Yes, we're trying to see if your client is in the hall.
Judge, I have not spoken with Mr. Lee. I've called all the numbers he gave me and all the numbers his bondsman gave me. I spoke to his co-signer, not his co-signer. I haven't heard from his co-signer. I spoke to his friend who said she contacted him and gave him the Zoom coordinates, but I haven't gotten in touch with him since the last time we spoke when he was out of state working in Georgia, I think.
Okay. Well, if he doesn't make an appearance, his bond may be forfeited.
And Judge, he may, I know it's not critical to a court this morning, but he may have I think he has a couple other things coming down the,
Yeah, I see
Coming
on
down
the
the
note
pipe.
it says unindicted felony, but that's a note that we have on the docket sheet.
yes, sir.
Okay, so you'll be free to go if he makes an appearance. We have a number that we can contact you at.
Judge, thank you so much. Be safe.
Okay, all right, and thanks for being patient with us, and you be safe as well. You have a blessed day.
Thank you, Your Honor. Bye-bye.
Bye. Okay. Is and Mr. Bacon, the state has dismissed your case in cause number 329710. Once you get your dismissal, you'll be free to go and you have a blessed day. All right. Okay. Joel's
You have to
time.
go out the other door.
Must be Joe's client. Call Joe to let him know his client is on Zoom. App share. That's app share is just coming through. Flowers. Yeah, that judgment on flowers. Pages. That's Mr. Vasquez. Okay, we're back in session in clause number 328158. Case is filed, the state of Texas versus Aaron Brennan Lee. I think we have Mr. Lee appearing via Zoom. Mr. Lee, you can take your mic off of mute. Yeah, you're still on mute. Mr. Vasquez.
Yes, Your Honor.
Mr. Vasquez, is that your client, Mr. Lee, appearing via Zoom?
Judge, I called in. I was having internet instability, so I just called in. I got a call from
Right.
Mr. Redmond telling me that Mr. Lee had just appeared by Zoom.
I think, but he doesn't have I'm trying to get him to take his mic off of mute, but he cannot, apparently he still have it on mute. Yeah, I can see a picture of him, but I can't hear him say anything. And so I was gonna see if you could appear via Zoom and identify him.
Judge, let me try and get on again.
Okay.
Bear with me, please.
Hey, how you doing, Kim? Huh? Oh, he's connected now? Okay. Yeah, Mr., take your mic off of mute. It's on mute. Take your mic off of mute. You're still on mute.
Tap the screen, and then you should have the option to take it off mute.
You're probably gonna maybe talk in this mic. He might be able to hear.
If you tap your phone screen, it should show up at the bottom of the screen, unmute, and in the bottom left corner.
Okay,
That's video.
that's the video. What happened? Okay, now he just went off a video. What happened? We lost it? Oh, what? Hold on. Joe, he just went off. I guess he's gonna come back on. Just. I guess he's gonna come back on. We had him there and it was trying to tell him how to get his mic off of mute, and some kind of way we lost him. We lost the video.
Yes, sir. I don't think I have a good number for him, Your Honor. Otherwise, I'd call him and.
Oh, I think he's coming back on. Is that your client?
That is not Mr. Lee, to my recollection.
Okay, who is he? Sir, what's your name? Your mic is on mute. I wonder who that is. Sir, your mic is on mute. Yeah. We may have to go on to the next case. Oh, here we go.
Still muted?
Yes, yeah, you're not on mute anymore. What's your name?
Okay, I'm Max McElwee.
Oh, that's Mr. Yeah, that's Mr. Paget. Oh, okay.
Yes, sir.
Okay. Call Mr. Paget, let him know his plan is on. Okay. I'm sorry about that, Mr. Vasquez. I didn't know. I thought that might have been your client.
Judge, I don't mind, except I don't like Mr. Paget cutting in front of me again.
Yeah.
Thank you anyway, Your Honor.
Okay, Mr. McElwee, just hold on. We're gonna wait for your attorney to get on Zoom. He was on Zoom earlier.
Yes, sir.
Okay.
May I be excused, Your Honor?
Yes, you may be excused, Mr. Vasquez. Sorry
Thank you,
about
Your
that. Okay.
Quite all right.
Mr. Okay, we're in session at cause number 327762. Now, Mr. The case is styled the state of Texas versus Call Wayne Flowers. Okay. Okay. Your name is Call Wayne Flowers. Mr. Flowers, would you please raise your right hand? Mr. Flowers, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? You may put your hand down. Mr. McElwee.
Yes, sir.
Could you put your mic on mute until we tell you to take it off of mute? We're in session in court.
Yes, sir.
Okay, so we got a record. You like to have a record in this case?
We can waive your.
Okay, you're gonna waive the record. Okay, now, Mr. Flowers, first of all, I have before me a psychiatric evaluation that was conducted by Dr. Edward Gapon. It was dated December 6th of 2020. And State, did you get a copy of the motion? I mean, the psychiatric evaluation?
Yes, Your Honor.
Defense, did you get a copy?
Yes.
And Mr. Gilthorpe, do you have any objections to the finding, conclusions, and recommendations in this motion?
No.
I mean, in this evaluation?
No, good.
And Mr. Boyd, do you have any objections to the finding, conclusions, and recommendations in this evaluation?
No, sir, Your Honor.
Okay, the court is going to take judicial notice of the psychiatric evaluation that was conducted by Dr. Edward Capon, in that he found that Mr. Flowers was competent to stand trial. Now, Mr. Flowers, I have before me an information that alleges that on or about August 8th of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you allegedly committed the offense of driving while intoxicated. Mr. Flowers, do you understand what you've been charged with? Okay, and to this charge, how do you plead? Guilty, not guilty, or no contest? Guilty. Now, are you pleading guilty, I see it, freely and voluntarily? Is somebody forcing you to plead guilty? What did you say? Mr. Flowers, why don't you come and stand right here? Stand a little closer to me. You can stand on, yeah, stand on that X. Now, Mr. Flowers, is anybody forcing you to plead guilty? No? All right. Now, Mr. Flowers, are you pleading guilty because you are guilty? Yes? All right. Now, Mr. Flowers, I have before me a document that is titled the Misdemeanor Plea Admonishments. Do you recognize this document? Let me go to the second page of this document. Mr. Flowers, did you place your initials on this document?
Yes.
Yes. And on page 3 of the same document, Mr. Flowers, is that your signature above the line that's titled Defendant?
Yes.
All right. And Mr. Flowers, I have another document here. This document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Flowers, do you recognize this document? Is this your signature on the line that says Defendant? Yeah, it's, yeah, what you was reading was right. Trial Court Certification of Defendant's Right of Appeal. Did you recognize this document? Right. That's right. Now, is this your signature on this document?
My signature.
Right. And that first box just check states that this is a plea bargain case, and as you read, the defendant has no right of appeal. Do you understand that?
No right of appeal.
Right. You understand that?
No.
You don't understand that?
No right of appeal.
Right. Did your attorney explain that to you? You explained it to him?
Yes. Sir. Mr. Flowers, this is the part where we talked about that if you go through with this plea, you're giving up rights of appeal, then you could not come back at a later date and decide you wanted to fight this case. And so the rights of appeal, when you accept a plea bargain, you're giving up those rights of appeal, and that's what we explained, and that's what you and I both signed. Do you remember that?
Yeah.
You do? Okay. Now, the second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yeah, my right to appeal.
You're giving it up.
What is this about? A DUI?
Yeah, it's about, well, you calling it the DUI, but we call it a DWI. It's this, yeah, driving while intoxicated. Okay, so my question is, do you understand that you're waiving, which means you're waiving your right to an appeal, which means you're giving up your right to an appeal? Do you understand that? Yes.
You're giving up your right to appeal the conviction, the plea of guilty, and any sentence imposed by this court.
Okay. Let me do this here. Let's take a recess. Okay. Just go ahead and have a seat. You can talk to your attorney. Just, we're gonna take a recess at this time. Okay. We have, Ashley Benoit. Ms. Benoit, would you please come forward? You can stand on the X in front of the bench. Your full name is Ashley Ann Benoit. How you doing, Ms. Benoit? I'm doing fine. Now, Ms. Benoit, the last time you were here, your case was reset to give you opportunity to hire an attorney. Have you hired your attorney?
No, sir, not technically. I called and tried to explain to one of your clerks, I had COVID and I've been pretty sick the last few weeks.
Okay.
I did meet with a couple attorneys and I just wasn't okay and comfortable with the price. So I wanted to have a chance to.
Okay, so you're doing all right now?
I'm doing better now. I did explain to her that my COVID test still was saying positive, but she said I still needed to show up.
Who told you that?
I don't know her name, but so.
Well,
Yeah.
you wasn't supposed to show up with a positive COVID test.
Yeah, that's what I thought.
Well,
I did.
your case is gonna get reset.
Thank you.
Okay.
She definitely told me, quote, it wasn't her, her problem, that my lawyer needed to call. to
Okay,
say
so
that.
you talked to her.
Yeah, she talked to me yesterday and I asked her that she would have to provide proof to the court of her COVID testing.
Right,
She
and
said
I'm
she
not-
had hired an attorney, and I said, we didn't have any attorney rep letter on file for her to get with her attorney. They will file an attorney rep, and she could then speak with the attorney about her having a positive COVID test, but she said she wasn't sure if she was positive or not.
But I did explain to you that I had taken two and they were positive, still even though.
And I just told her she.
Okay, well, just reset her case. Okay, you can get your reset and you'll be free to go.
Thank you.
I'm gonna say it's 4/11/17.
Mr. Paget. We
Yes,
have
Your
your,
Honor.
we have your client, Mr. McElwee, who is appearing via Zoom. Mr.
Yes,
McElwee,
Your Honor.
Mr. McElwee, you take your mic off of mute.
Yes, sir.
Okay. Okay, now, Mr. Paget, what's your announcement in Mr. McElwee's case?
Your Honor, this morning I received an offer, well, actually yesterday I received an offer from the state. I now have all discovery except for the video evidence. So I'm unable to make an announcement at this time due to the fact I don't have that video in my hand right now.
How much
And
time,
once I get it,
how much time do you need?
just a regular reset, Your Honor. I requested it about 2.5 weeks ago. So I expect it to be in, pretty soon. They seem to be running a little bit behind on the videos lately.
Reset? Yes. The standard reset, he said. Okay, the case is gonna be reset to November 17th. Mr. McElwee.
Thank you, Your Honor.
And Mr. McElwee, stay in contact with your attorney. You're free to go and you have a blessed day. And Mr. Paget, your reset will be sent to you. You're free to go and you have a blessed day as well.
You have a blessed day as well, Your Honor. Thank you for your patience.
Yes, sir. Thank you, Your Honor.
All right.
Take care. Thank you.
You're welcome.
Good.
You say Barnett? Yeah, Barnett and Vasquez. Right. And we got Perry. Okay. I guess we could go ahead and do Perry, that's the one. Whose case was that? Hold on, that's flower stuff. And hold on, this goes with it. Right, yeah. Okay.
Thank you.
Are we ready in cause number 3265502, State of Texas versus James Parrott? Okay, let's see, we have Mr. James Parrott, who is appearing before the court, and we also have, well, first of all, Mr. Parrott, how you doing? I'm doing fine. Mr. Parrott, you're represented by your attorney, Mr. Nathan Reynolds. Mr. Reynolds, how you doing?
Fine, Judge.
That's good. Mr. Boyd, are you handling this case?
Yes, Your
This is okay. Now, we appeared in court on September 15th, which was about a week ago. And at that time, it was set for on the announcement docket. This case was set on the announcement docket. And then the court noticed that that Mr. Parrott had an assault family violence case. And so the court proceeded with giving Mr. Parrott the standard bond conditions in county court at law number 2. And the third condition was that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And I think at that time, Mr. Reynolds, Mr. Parrott's attorney, requested that condition not apply to Mr. Parrott, because I think that he and the victim Or,
They're married, they've been married for 10 years. I don't believe she'll cooperate with this case. But she's indicated through him that she doesn't feel any danger from him being there. And of course, if to abide by that bond condition.
let me do this. Okay, go down.
To abide by that bond condition, if he has no other place to live, it would make him homeless and would work an extreme hardship for him and the victim.
Okay, now, Mr. Boyd, have y'all been able to contact the victim?
Looking through the notes, Your Honor, and, let's see. It looked like they, yeah, I think this one, they are, it's my understanding that they were still living.
Well, my question is, have y'all been able to communicate with the victim since September 15th to see what her, what she thought about this particular condition?
Yeah, well, obviously, when it was initially contacted, she felt like she wasn't still in danger with regard to this case, as far as that, we're still going, I explained to her that our choice to go forward with that, if she wanted to, not to do that, what things she might have to do.
Okay, did y'all contact her about this hearing today?
I'm not aware, I didn't contact her about this hearing.
Okay, well, I know his attorney has represented that. She said she was not in fear or any danger.
I think she has a warrant. I believe she may have a warrant out for her.
Well, I'm not comfortable in removing this requirement. I mean, till we get some input from the, at least some input from the victim. Because I know, I mean, what you're saying is more or less an argument, but if we can get some testimony from the victim expressing her, then the court will be a little bit more comfortable. And then,
I'm sorry.
yeah, so that's my thing, because I'm totally unaware of a warrant or anything of that nature. But
could we reset it for another week?
Yeah, we can do that.
I think I would. I'm representing the court. What information I get.
Right, I'm saying.
I think it would certainly carry more weight if that same information came from the district attorney.
Right. Okay. So yes, that's what we do. Let's reset him another week. Okay, we had his hearing a week. Are you available? You available? Okay. Okay, we'll do that. All right. You can get your reset. Mr. Perry from your attorney, once you get your reset, you'll be free to go. And Mr. Reynolds, once you get your reset, you'll be free to go as well.
Yes,
and
sir.
both, Mr. Perry, you have a blessed day and you have a blessed day as well.
Thank you, sir.
You're welcome. That's it.
Wait a minute.
Mr. Barnett, please come forward. Okay, we're in session in cause number 321-844. Case is style of State of Texas versus Kenneth Dushawn Barnett. Is that correct?
Yes, sir.
How you doing, Mr. Barnett?
All right, sir.
That's good. Mr. Barnett, you're represented by your attorney, Mr. Antoine Freeman, who is appearing via Zoom. Mr. Freeman?
Yes, Your Honor. Can you hear me?
Yes, how are you doing?
I'm good, Your Honor.
Okay, that's good. Mr. Freeman, Mr. Barnett's case is on the court's announcement docket. You have an announcement you'd like to make in Mr. Barnett's case?
Your Honor, I haven't talked to Mr. Burnett. I didn't even know we were scheduled for today. So I would ask that it be placed on another announcement docket, and hopefully Mr. Barnett would call me today so I can know exactly what's going on with his case.
Okay, okay, we'll do that. Mr. Freeman,
Yes.
hold on a minute, so I can give you a reset date. Okay, this case is gonna be reset to November 17th of 2021. And Mr. Freeman, your reset will be sent to you. This will conclude your case. You're free to go and you have a blessed day.
And Your Honor, if you could you give Mr. Barnett my number so he can call me, because I haven't talked to him and I need to.
It's gonna appear on his reset that he's gonna get.
Okay. Thank you, Your Honor.
Okay, you're welcome. And you have a blessed day.
You too.
Mr. Burnett, okay, just hold on, when he finished, you're gonna go over there, get your reset. Once you get your reset, you'll be free to go. You have a blessed day. Stay in contact with your attorney and your bondsman. Okay? And then we're gonna have Mr. Flowers stand here because his,
Stand over here and try and speak a little louder.
yeah, because the microphone is right here. The microphone is right here.
All right.
All right. Now, we're back on the record in cause number 327762. The case is styled the state of Texas versus Carl Wayne Flowers. We have before us Mr. Carl Wayne Flowers and his attorney, Mr. Jared Gilthorpe. And prior to the court going into recess, Mr. Carl Wayne Flowers entered a plea of guilty to the information, which is the charge of driving while intoxicated, which is Class B misdemeanor, and the court had presented State's Exhibit Number 1, which is the misdemeanor plea admonishment to Mr. Carl Wayne Flowers, and Mr. Carl Wayne Flowers acknowledged that his initials was on page 2 of this document and his signature was on page 3. And then when the court proceeded to the trial court certification of defendant's right of appeal, the court asked Mr. Flowers whether or not he recognized this document. Now, we will start there again because we did not complete the process. Now, Mr. Flowers, do you recognize the trial court's exhibit? What is it? Trial court certification, defendant's right of appeal.
You're talking about,
Have you seen this document before?
yeah.
Yes? All right. Now, is this your signature where it says on the line that says defendant?
Yeah.
And at the top of this document, there are 2 boxes that are checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
No right of appeal.
Yes. And I think that's where we were when your attorney explained to you what that meant. Okay, so the first box, see, there's 2 boxes checked right here.
Yeah.
The first box says that This is the plea bargain case and the defendant has no right of appeal. Do you understand that?
Oh, they're saying I can't come say no to whatever.
I couldn't hardly hear you.
Huh?
Do you understand that you do not have a right of appeal?
I can't appeal the case.
That's right. You can't, yes, right. You cannot appeal the case. Okay. And and the second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Oh, kind of, let me see. I'm saying I can't.
I know it's kind of, it's
Right.
one is saying you don't have a right, and then the other one's saying you're giving up something you don't even have a right to. That's,
Yeah. So, what's the case about a DUI? Sam?
well, you calling it a DWI, we call it a DWI.
Oh, sure.
So the question is and we back at that same point. Are you waiving your right to an appeal? Do you understand that you're waiving your right to appeal, or are you giving up your right to an appeal?
Well,
You understand that?
DUI, when I got the DUI, I got it at the house.
Well, you can, your attorney can go over that with you. I mean, you talk to your attorney. You need some time to familiarize yourself or re-familiarize yourself with the facts of the case. I'll give you time to do that with your attorney, okay?
Oh, no, we can get this over with. What? Let me see.
Oh, you want to take a look at it again?
Yeah.
Okay, this is a trial court certification of defendant's right of appeal. The first box that you said you understood that says you are waiving, as this is a plea bargain case, you have no right of appeal. And the second box that's checked states that you're giving up your right to an appeal. Do you understand that?
Oh, yeah.
Okay. Now, do you have a trial court certification?
I did hand it
Oh.
one earlier.
Oh, yeah. Now, Mr. Flowers, I have before me a document that is titled the Discovery Certification. You recognize this document? Have you seen this document before?
Yeah.
Yeah? All right. And is this your signature on this document?
Yeah.
Yep. All right. Now, Mr. Flowers, all of these documents that I just went over,
Yeah.
did your attorney go over these documents with you?
Well, what is it about a DUI or something?
Right? That's why we hear you calling it a DUI. We call it a DWI. It's driving while intoxicated. Do you remember going over this document with your attorney? Do you remember going over these documents on this tablet that have your signature and initials on it with your attorney?
Yeah.
Yeah? Okay. Now, did you understand what your attorney went over?
Yeah, well, we got this DUI.
Okay, let me ask one question at a time. You can answer one question at a time. Did you understand what your attorney went over when he went over these documents with you? Huh?
Yeah, I have no right to appeal.
Yeah, that's one of them, but I'm just saying, out of all of these, the information that in all of these documents, did your attorney go over these documents with you?
Yeah.
He went over it. Okay, good. Now, did you understand what he went over?
Kinda.
What do you say? He said kinda? Okay, well, we can't go forward on that until you get a thorough understanding of what your attorney went over, okay? So just, we may reset this a week.
Okay.
Give you a week to go over it.
Go ahead, that's fine.
I'm just saying.
Yeah.
I don't know how long it's gonna take you to go over it with him.
I'll revisit with him.
Okay, okay, we're gonna reset him a week. Okay, just stand over there, the case is gonna be reset a week.